Thank you so much for joining us. My name is Bethany Hamilton. I'm with the National Center for Medical Legal Partnership at the George Washington University. NCMLP is also joined by health outreach partners. We partnered together and are collaborating on providing this unique webinar series to provide trainings on highlighting the unique role of medical legal partnerships in helping health centers address disability and chronic disease discrimination. Today is May 11th, 2022, and webinar number 2 in the series covers disability and chronic disease discrimination with kids, helping health centers really better understand their role in securing legal protections for pediatric patients. I'm just providing some brief remarks on behalf of the National Center for Medical Legal Partnership and HOP to welcome everyone to today's webinar series. We'll have a poll so that we can better understand who's joining us in the audience today. And that'll help us also provide some housekeeping bits of information so that you understand how you can better engage as an audience with our subject matter experts and who are panelists on today's webinar. Let's run the poll. So this is just a simple icebreaker poll. If you attended webinar number 1, we wanted to know what's your favorite pizza topping today. We'd like to know, were you human? Did you have, or what did you have for lunch today? Did you have pizza? Did you go get a classic sandwich from somewhere? Did you eat some greens, salad? Are you grazing on snacks? Did you not have lunch yet, like some of us? We hope you did. So go ahead and fill out the poll. Also, let us know who you are in the audience. Are you health center staff? Are you with civil legal services? Are you a member of the disability advocates community? Are you with a hospital, a university, or academic institution? Are you with a government agency? Or are you in another category that is not already covered? Go ahead and fill out the poll. So we'll give you all about 30 more seconds to continue filling out the poll today while I cover some housekeeping remarks. Let's go to the housekeeping slide and make sure everyone knows how to engage with us. Just a moment before I get to that and those instructions on housekeeping, I just want to acknowledge that this webinar series is supported by the Health Resources and Services Administration, or HRSA. Both for NCMLP and HOP, we are collaborating on HRSA's National Training and Technical Assistance Partnership Award. Next slide. All right, so in a moment, I'll transition to our NCMLP consultant, Katie Hathaway. Let me close out the poll and let everyone know that most folks actually haven't, and this is unfortunate, had lunch yet. Most folks in the audience are in fact from civil legal services, some of whom may actually have a medical legal partnership. Some are perhaps having conversations with those health center staff or other healthcare folks in the audience today who would like to start medical legal partnerships. All right, let's close out the poll. Before I pass it on to Katie Hathaway, I just want to make sure everyone knows that we are running this webinar using the Zoom platform. So please ensure that you take a look at the navigation bar to utilize the questions and answer function so we can capture the Q&A and be able to have panelists address those questions that come in. But you're also welcome to use the chat function if you'd like to share commentary as well as additional questions. We'll ensure that we monitor it and get back to you. This webinar is also utilizing American Sign Language interpreters, and so we want to thank them for joining us today and providing their services to our diverse audience. With that, I'm going to pass things on to Katie Hathaway. This is Bethany Hamilton from the National Center for Medical Legal Partnership, closing out.
Thank you, Bethany. As Bethany said, I'm Katie Hathaway. I'm serving as the moderator and a speaker for today's webinar. I am a consultant for the National Center for Medical Legal Partnerships and have nearly 20 years of experience working as a disability rights attorney. I spent 17 of those years helping to build and then leading the American Diabetes Association's legal advocacy program, which seeks to end discrimination against people living with diabetes. So that is who I am. I will introduce you to the other speakers as we get further along into the presentation, and they will introduce themselves. But just to let you know, I am a white woman with long, straight, medium brown hair, brown eyes, wearing a blue jacket and a green shirt today. My pronouns are she, hers. So what are we going to cover today? The webinar 2 weeks ago was focused on legal protections, some common barriers, mostly in the employment and public accommodations arena. Today's presentation is going to focus on the legal protections available for children with disabilities and chronic disease in the school setting, in colleges and childcare programs, and also in immigration custody and proceedings. We're going to talk a bit about the role of health centers in supporting pediatric patients or clients and their families in these systems. We'll talk a bit about the federal government's role in enforcing the civil rights of students with disabilities. We'll talk a bit and run through some scenarios about what does disability discrimination look like in practice, and in particular, the role of COVID-19 in these scenarios. And at the end, we have left some time for an open question and answer period. And we do hope that you will think of some questions. If you have them in the moment, jot them in the question and answer box on Zoom, and we'll monitor that. And if we can, we'll address them as we go. And if not, we will get to them at the end. But I do hope that you will take advantage of that. So we're going to start by talking about the legal protections in education. And education broadly is going to cover a lot of different areas. The federal laws that cover this section. Two of these we talked about in the last webinar, if you joined us for that one, and a third one will be new to this arena, but how they apply will look a little different for this population. So both the Americans with Disabilities Act and the Rehabilitation Act of 1973 prohibit discrimination on the basis of disability by a bunch of different entities. Of the ADA and Section 504 of the Rehabilitation Act will apply to all public schools and some private schools. The ADA will not apply to schools operated by a religious entity unless they receive federal financial assistance, so money from the federal government, in which case that would bring them under the umbrella and subject to the protections and obligations of the Rehabilitation Act. Title III of the Americans with Disabilities Act is going to apply to places of public accommodation. And in this area, that means usually many, if not most, private childcare and other daycare programs, and colleges and universities, depending on their structures. Like I said, how it applies exactly will depend on the entity and how they are either funded or structured. To be eligible for sort of services and protections of these laws, a child must have a disability, which the law defines as a physical or mental impairment that substantially limits one or more major life activities. If you joined us for the first webinar 2 weeks ago, we covered this concept in a little bit more detail. In this education context, to be covered, it's not necessary that a child have a disability that impacted their ability to learn. It is for protections under one of these laws, but it is not for all of these laws. So a student may need an accommodation for a disability in order to fully access their education, to participate in activities, and to do so safely. So diabetes, for example, is an example of a federally protected disability that does not typically impact a child's ability to learn, but does require some accommodations from the school or the entity in order to manage that condition while the child participates. The third law that is listed here is the Individuals with Disabilities Education Act, IDEA, which requires states to provide what's called FAPE, a free, appropriate public education to eligible children with disabilities, and ensure that those children receive special education and related services to help them learn. So as I mentioned, under the Americans with Disabilities Act or Section 504, the child does not need to have a disability that impacts their ability to learn in order to receive services and the protections of those laws. Under IDEA, they do. So for children who have disabilities that have a substantial impact on their ability to learn, they are eligible for services under IDEA. It's important to note that whereas some children who are eligible under Section 504 will also be eligible under IDEA, not all of them will. but all children who are eligible under IDEA should be eligible to be covered and receive services under Section 504. So let's talk a bit about the role of states and state laws. The IDEA governs how states and public agencies provide early intervention, special education, related aids and services to millions of children with disabilities, from infants all the way up to older youth with disabilities. It is administered by the states and local education agencies with funding from the federal government. That funding is provided from the federal government annually through two types of grants, what are called formula grants that are based on several different population factors, and discretionary grants. It's also important to know that state law can impact and affect how a child's rights are carried out. How does it happen? And it's possible that a state law may require more of an entity than federal law, but that state law cannot require less than federal law. That state law may impact how certain services are provided. For example, how medication is collected or stored, how it's actually administered, the recording of the administration of that medication, who supervises the administration of that medication, what training or certification, what type of school personnel is allowed to perform that function, the dispensing of medication. A lot of those things are often written into state law and do not undermine the federal protection, but provide more guidance and direction on how those related aids and services should be provided. So it's important to know your state law to really fully navigate this area. So what are some of the real basic protections against discrimination? There are what discrimination is or isn't, like I said, will look different depending on the type of entity and the type of the stage of education, I suppose you could say. I'd like to call these sort of two different, the K through 12 elementary and secondary schools, public or private, depending on which laws apply, and then what I call the bookends, which are really the daycare or childcare, and the college and university. And these are different, the same laws, but different protections. So for the K through 12 schools, you'll see on the screen that there are 4 different sort of major topics covered here. The first one, as I referenced talking about the laws, is what we call FAPE. Free appropriate public education. This is the standard under both IDEA and Section 504. It may include education in a regular class, education in a regular class with the use of related aids and services, or special education and related services in separate classrooms for all or for portions of the day. It'll be very individualized. Evaluation and written plans. Both 504 and IDEA require that students be evaluated to determine both their eligibility for services and that the schools have a proactive obligation to identify students who may need those services. Either a school or a parent can initiate and request the evaluation process. The results of evaluations and the needed services should be documented in a written plan. Under IDEA, these plans are known commonly as Individualized Education Programs, IEP. Under Section 504, they are commonly just referred to as 504 plans. Whereas the IDEA does require that has a specific requirement for a written plan, Section 504 does not, although best practice really is to memorialize all agreements about the child's eligibility and the services in writing. The third one, least restrictive environment. IDEA requires schools to ensure that children with disabilities are educated with children who are not disabled to the maximum extent appropriate. And that's special classes, separate schooling, removal of children with disabilities, all of those things, removal from the regular educational environment, that those only occur in limited circumstances. And finally, procedural protections. Both laws provide protections to ensure that the education process includes input from the child if it's appropriate and or their parents or guardians. And if a parent or guardian feels that a child's plan is not appropriate or their child is not receiving the needed services, they have a right to due process to challenge that treatment or that plan. And finally, for what I call the bookends, a lot of the protections here are very similar to what we talked about 2 weeks ago with regard to places of public accommodation and the standard being reasonable modification of policies. These are really changes to the way that something is typically done to allow access or participation by the person with a disability. For the most part, IDEA is not going to apply to a standard daycare program, but the ADA and or Section 504 will. Likewise, although a college or university doesn't have the same affirmative obligation as a public K-12 school does to provide FAPE, to identify students with disabilities, and is really unlikely to convene a team of people to develop a written plan. Institutions of higher education cannot discriminate against students with disabilities and may need to make modifications, changes to accommodate those students. So for example, a daycare may need to modify policies that prohibit the administration of medication by daycare staff so that a young child with epilepsy can attend and can have access to seizure medication. A college may need to adjust policies around rescheduling exams due to medical emergencies to accommodate a student with diabetes who may be experiencing unsafe blood glucose levels. Just a couple of examples in this space. So next we are going to talk about the legal protections in immigration custody and proceedings. And to do so, I'm going to introduce you to my good friend, Catherine Gordon. Catherine is a staff attorney with the Detained Adults Program at the Capital Area Immigrants' Rights Coalition, where she works with immigrants with mental health disabilities detained in the DC, Maryland, Virginia region. Prior to this, she worked at El Otro Lado in Tijuana, Mexico, coordinating the pro bono response to the previous administration's metering and migrant protection protocols policies, which prevented asylum seekers from meaningfully exercising their right to request protection under international and federal law. She also worked as a child advocate with unaccompanied minors, including children with developmental and mental health disabilities who were detained by the Office of Refugee Resettlement. Before shifting to immigration advocacy, she worked with the American Diabetes Association's National Legal Advocate Program, where she helped people from across the country fight discrimination in employment, education, public accommodations, correctional facilities, and interactions with law enforcement. Catherine is a former Georgetown University Women's Law and Public Policy Fellow, a graduate of Bryn Mawr College and the George Washington University Law School. Catherine, welcome and take it away.
Thank you so much. So I am a white woman. I am wearing a jacket and a blue shirt, and I have glasses on. I have dark hair, and my pronouns are she, her, Aya. And I wanted to just talk a little bit about an overview of this. First of all, I just wanted to express my appreciation for being with healthcare professionals. I feel like throughout my life, throughout my legal career, whether or not it's a disability context or immigration or combined, so often problems have been solved at a quick, efficient level by the intervention of healthcare professionals. So whether or not that's an endocrinologist who helps get a 504 plan in place, or whether or not it's a general medical doctor who reviews records that allows us to get appropriate mental health treatment and even release of a detained client. I think that the way in which there can be quick resolution of problems is really incredible. And so I just wanted to just say that I'm really happy to be here for that reason in particular. A few kind of overview things. I think immigration law is about as complex as tax law. So just some very brief kind of comments. One is that the anti-discrimination statutes and the regulations that Katie talked to apply equally to non-citizens. And I think that's important, especially for the Americans with Disabilities Act. We might not think of that as applying to a person who is a lawful permanent resident or undocumented, but in fact, that does apply. I do think that in the space of immigration law, the area that is most significant is probably the Rehabilitation Act and Section 504 of the Rehabilitation Act. While Katie has talked about how it applies to organizations that receive federal funding, in the case of immigration, very often it is the federal government which operates different programs and activities itself. And it itself is, again, held accountable to the same disability rights protections. So that's an overall view of the same laws do apply. However, I do think that it is important to recognize that sometimes the rights that folks have and some of the due process rights can be pretty different. And so, for example, a person has the right to have counsel in criminal proceedings, but there isn't a similar right in immigration proceedings. So a lot of folks who are in immigration custody are detained, don't have a right to any counsel. And so themselves, including children, will represent themselves at times, even 10 years old, which can be a bit concerning. Another thing that is really real is the risk of retaliation, where people, if they want to exercise their rights, if they want to get a 504 plan, for example, they can in fact be retaliated against. It's not legal, but it can happen. And I think it's important to identify that. And I think that especially as healthcare professionals, you're very, very used to using discussions around informed consent, especially if something is a bit more complicated. If you're looking for experimental treatment or operation, you really want to make sure that the individual understands what the risks and benefits are to any certain thing. And I think that's a good way of discussing these issues. So if you want to talk with a person about, do they want to exercise their rights? What would be the risks? What would be the advantages? And really helping them make their decision. Sometimes they may decide that to protect their family, they don't want to go forward with their rights, whereas another person might decide that they do want to. And I think just really being a sounding board and providing some advice in that level is really important. I think another thing that is wonderful about HRSA is that HRSA and the federally qualified health centers really are the places where folks who are undocumented or who don't have stable immigration status can get care. And so I think that that's a great thing to know. And we constantly are referring our clients in the immigration context to qualified health centers. So I wanted to next talk about a few different examples. One example is unaccompanied minors who are in the Office of Refugee Resettlement Custody. So for your knowledge and background, kids who arrive to the United States without their parent are generally detained in a shelter that is run or contracted by the Office of Refugee Resettlement. They are supposed to be released promptly to a family member who can care for them while they're in immigration proceedings. The beginning of that started with the Flores versus Reno settlement, which really indicated that kids really did need to be released to language very similar to the least restrictive environment, to say that kids should be in the community as much as possible while undergoing their immigration proceedings. It's not identical to what Katie was speaking about with the least restrictive environment, but it does really say that kids really should be in the community whenever possible. So, and that it has been the subject of current litigation. One of the things that we saw specifically starting in about 2013, 2014 under the Obama administration is that children with mental health disabilities or cognitive disabilities, intellectual disabilities, whether or not it's PTSD or autism or Down syndrome, often were put into residential treatment centers with very little oversight, and in some cases, very frequently subject to chemical restraint. So essentially, kids on a weekly basis being forcibly injected with powerful antipsychotic medications, or given, quote, vitamins, which are actually antipsychotic medications that doubled these kids' weight in a few months. So there was litigation regarding that. that, just was very disturbing. But I think that one thing that has been great is that healthcare professionals and disability rights organizations and immigration organizations have come together to say, look, this is really in violation of the concept of the least restrictive environment. And that's really caused some changes for how kids are treated. Another area is prolonged detention of kids with disabilities, and also denial of release of kids to sponsors with disabilities. And I'll go on to the next slide. One area that I think you might be likely to see some immigration concepts in play is DACA, which is a deferred action for childhood arrival. And that's a project that gives people who came to the United States, they had to be in the United States by 2007, but who came here as children. And this gives them work permits and allows them to have protection from removal and deportation. One of the challenges with this is that a requirement is that kids are in school, have to be in school, they have to have a GED, or they have to have graduated. And so you can see how if a kid doesn't get the free appropriate public education or isn't getting the care that they need in school, whether it's through diabetes or deaf or hearing impaired or ADHD, the child might not be continuing on in school, and that can put them at risk of losing their work permit and even put them in removal proceedings or even cause their deportation. So getting things right at the beginning is really critical. And then a next area of concern and advocacy is that this is more for adults, is that currently since March 2020, Title 42 has been in place. And this is a public policy health law that restricts the ability of asylum seekers to enter the United States. Fortunately, the administration is seeking to end this. But this has caused a very strange situation where individuals who have a very strong asylum claim, many of them do, are not allowed to ask for asylum, although it's crystal clear in the law that they have that right. And so they are forced to wait in Mexico or deported without any paperwork. There have been, through organizations like Human Rights First and other organizations have documented thousands and thousands of people who have been subject to kidnapping or assault, rape, robbery, or even death while they're waiting. And it's concerning here because asking for asylum is not considered essential travel, including for people with disabilities, whereas going to Tijuana for a weekend on spring break is. So hopefully this will be a thing of the past. Another thing that's also really important is case law Freihat versus Immigration and Customs Enforcement, which started out as a disability rights litigation, actually, about how people with mental health disabilities were held in detention. But with COVID, it turned into a class action where people were able to have a custody review of whether or not they should be released from immigration detention if they had a disability or an underlying health condition that would put them at risk of COVID or more serious COVID-19 infections. I'm sorry, here we go. And so that has actually allowed for the release based on disability rights for thousands and thousands of people who have been determined to be at high risk, but also not at danger to the community. And I think that that's just a great success that I'm just really happy to be able to share. And then I wanted to just finish up a little bit with some of the resources that are available. For folks who are interested in getting involved, because again, I think one of the areas where we can change some of these policies is through organization of healthcare professionals involved in this. Kids in Need of Defense does wonderful work across the country with kids in particular. If you have a patient who might be interested in getting immigration help, the Immigration Advocates Legal Directory, you put in your zip code and you can find great organizations. The National Center for Youth Law has done phenomenal work with disability rights organizations on the Office of Refugee Resettlement issue. If you're interested in working with asylum seekers or others on helping to document their disabilities or their need for asylum, Physicians for Human Rights has done work for decades, and And Capital Area Immigrants' Rights Coalition, again, we have a very robust volunteer program, and we really appreciate the opportunity to work with medical providers, and we'll be starting up an official medical legal partnership in a few months. And thank you so much, Katie.
Thank you, Catherine. That is a lot of information, but a lot of great information as usual. So we're going to shift over to talking about the role of health centers in supporting pediatric patients with disabilities. And covering this is going to be my friend Gina Gavlak. Gina has 30 years of experience and leadership, program and fund development, advocacy, and direct patient care. As a nurse, community leader, individual, and mother of a child living with diabetes, she is passionate about improving access to affordable and equitable healthcare and eliminating health disparities. Since 2019, Gina has served as the Vice President of Business and Fund Development for Neighborhood Family Practice, a community health center located in Cleveland, Ohio. Throughout her career and as a former chair of the American Diabetes Association's National Advocacy Committee, she has extensive experience in legal, legislative, regulatory, and grassroots advocacy. Gina earned a Bachelor of Science in Nursing from Capital University. So Gina, over to you.
Thanks so much, Katie. And hi, everybody. I'm so excited to be able to be part of this discussion today, and I'm thankful for the opportunity. One of the things that I really wanted to focus on is just my personal and professional experiences and my volunteer experiences throughout my career and my lifetime, and how I've been able to use those in all of the positions that I've held to be able to advocate for patients, and in this case now patients of our community health centers in Cleveland, to be able to help them be able to have everything that they need in place for school, but also for work. So I think it's also important to remember that as we're talking about this, a lot of our pediatric patients are teenagers, right? And they actually are working as well. So anything that we're talking about, a lot of those concepts can be applied to the work world. I think as Katie mentioned, I think some of the uniqueness that I bring to the panel is, in addition to being a nurse, I have lived with type 1 diabetes for 42 years, and my son was diagnosed with type 1 diabetes right after he had started college. So as a mother of a child with diabetes, advocating took on a whole new role, and one that I was very familiar with in my many years of working with many families and many school systems throughout the state of Ohio, and especially in Cuyahoga County. So one of the things that I wanted to talk about today was, we do know as community health centers, and just I think as healthcare in general, the vast majority of management of chronic conditions takes place outside of the walls of our community health centers or outside of the walls of other healthcare organizations or hospital systems. And with that in mind, whether it's an adult, a parent, or a child who's living with diabetes, in order for them to be successful in their management of the chronic condition, it's incredibly important for them to be able to have different plans in place or accommodations in place at school, which we'll talk about here, but like I said, also work. And those accommodations then will help them be able to safely manage their diabetes, and then also be fully actively participating in whatever's going on, and in this case, in school. So some of the common challenges that are faced by pediatric patients, I think, and I don't want to read all the bullets across on the side or that are on the slide, but just talking a little bit more about these. So of course, undiagnosed or untreated issues that affect learning, attention deficit, hyperactivity disorder is definitely one of those. But we have to remember too, that there can be medical conditions that are undiagnosed and not being treated right now that can actually cause or impede one's ability to learn or learn effectively. A new diagnosis or a new school. The other big thing, families and schools that are struggling to come to agreement on what does that care plan look like at school. So whether it's for diabetes, asthma, seizures, depression, anxiety, we have to remember that it could be a physical need that somebody has, a mental health need, or a combination of both. Some of the other very common challenges that our families and pediatric patients face: no school nurses available. whether they're not available on site or they're not there during every day that the school is in session. What does this look like for field trips? What does it look like if your child's riding the bus or participating in extracurricular activities like sports or music or different things like that? And then what could potentially be making participation dangerous, that if they had some things in place, some accommodations in place, they would be able to fully participate in a more safe manner. One of the big things that we know that came across with COVID is no masking requirements at school, but a child is immunocompromised and at high risk of severe outcomes from a COVID-19 infection. And then patients transitioning to college without the same school or family support to manage their conditions. I think one of the other things that I want, Katie, before you advance to the next slide, just to kind of talk about here is, as community health centers, we are so uniquely positioned to be able to provide integrated care services for primary care and behavioral health at our locations. And we know that we serve a population where the vast majority of those who come to us for care are medically and or economically vulnerable. They're a very high-risk population. They're a population who has suffered trauma. We know that living in poverty has been identified as a form of trauma. So we know that there are so many different layers to what might be going on in the individual or family's personal lives that can be making what might seem like a simple thing to navigate that much more difficult to navigate. And Katie, you can go ahead and advance to the next slide. And this is where I'd like to spend the bulk of the time that I have for this presentation, is really talking about how we can support our patients as health centers, how we can be a patient advocate. And I think one of the most important things that I've learned throughout my life and my career is anyone can be an advocate. Anybody can. There's room for everybody to be involved, and everybody can be involved in a way that aligns and fits nicely with what they know, what they like to know, and what they'd like to learn. So I used to always tell people when I was with the American Diabetes Association and chaired the National Advocacy Committee that I am the poster child for anybody can be an advocate. When I was in high school and when I was in college, I knew there was a president, a House, and a Senate, and in the state of Ohio, a governor, a House, and a Senate. And just by working and learning more and learning how I could use my voice as a nurse, as somebody who lives with diabetes, and as somebody who is very, very interested and passionate about making sure that all people have equitable access to healthcare, but also equitable access to all of the other things that they need to live a full life. So some of the things that we can do in our health center environments, and I'll challenge everybody to kind of think beyond and stretch your imagination some and think about the ways that you can be involved, or that your health center at large can be involved. So the first one, screen for possible discrimination. It's so incredibly important to be able to listen to what our patients and their families are telling us. But while we're listening, we also want to be making sure that we're not only hearing what they're saying, but we're also watching their nonverbals, because sometimes those verbals and nonverbals don't align. And that opens a nice door for us to be able to jump in to ask some probing questions about how things are going at school or with daycare or college or work. So remember, we can also add work into this as well. I think one of the other things to really keep in mind too is throughout the conversations, words are so incredibly important, and words really matter. We need to make sure that we're using words that people understand, that we're using words that don't scare people or put them on the defensive. So different things that could easily put people on the defensive are words like disability. So as Katie mentioned earlier, diabetes is recognized as a disability. Well, as somebody with diabetes, I don't consider my diabetes a disability. As a mother of a child who has diabetes, and working with parents who have children with diabetes, hearing the word disability, you can see the cringe and you can see the, no, that's not what he has or she has or I have. So I think what's really important is to avoid starting with using words like that, and to eventually, as we're working to help educate people and helping empower people, is helping them understand that without the management and the treatment tools, whether it's for diabetes or asthma or seizures or depression or anxiety or ADHD, those conditions do become a disability. So a lot of times those factors that are used to manage are called those mitigating measures. And I'm not going to get into the weeds on all of those, but like I said, avoid words that might block the person from wanting to have more of a conversation. But then also ask questions. And we all know this in healthcare, right? We want to ask open-ended questions. So provide them an opportunity to be able to give you feedback for you to be able to build from. And then be really, really careful with how we respond. So we will always want to make sure, and sometimes, and I know as a parent, it doesn't even have to do with anything with that we're talking about today, but sometimes it's like, well, why didn't I know that? I should have known that. I'm the mom, or I'm the adult. Why didn't I know that? A lot of that people will go through and they'll be like, well, was I supposed to know that? I didn't know that. So just setting it up so that it makes the person feel like we expect them to have questions. We want them to have questions, and we want them to feel comfortable with asking those questions, I think makes an incredibly important difference. The other thing is troubleshoot potential things that you're noticing. So let's say like with diabetes that you're seeing significant swings. They could be highs or lows in A1Cs. If you're noticing that, that might be a great opportunity to be asking just different things about, well, how's school going? What do you like to do at school? What would be helpful for you with managing your diabetes at school? Or is there anything that you need? Or how can the school help you better manage your diabetes? By doing those different things, it actually will open the door. And maybe they tell you, you know what, my child's having a ton of lows because gym class is right before lunch. And he goes to gym, ends up having a low. And then the simple accommodation for that might be for a snack, the child to be able to have a snack before the child participates in gym class. So a lot of things are very easy. Same thing with asthma. Maybe you're noticing that they've had frequent admissions to the emergency department, more so during school hours. So that might trigger so tell me about how you're able to manage your asthma while you're at school. Do you have your inhaler with you? Are you able to use your inhaler? All of those different pieces, I think, help us put the pieces of the puzzle together and help us really figure out what the need is. And then for the second here, educate your patients about their rights. You don't have to be a lawyer to share basic information. All of us can do this. All of us can help educate patients about what their legal rights are. I think the most important thing to know is you don't have to be the expert on their legal rights, but it is so incredibly important that you know what the resources are, that you know what the different links are, the different websites are, the different community organizations. Also including things or thinking about resources such as legal aid. So who is in your community that could definitely help work with the population that you serve? And do you have that relationship built with that organization or those organizations? And if not, does it make sense for your community health center to move forward with getting those established? I think the other big thing too is if we look at number 3, provide active support. So community health centers as providers, as the healthcare providers, can play active supports by completing the medical care plans, school forms, answering questions from school personnel. I think the biggest thing with this is making sure that, and the other one in there is, of course, the letter of medical necessity, which in that letter of medical necessity, that would spell out what the condition is, would give some background about what the condition is, what that means for the individual who has diabetes or asthma or ADHD or depression or whatever the case may be. And then also making sure that that letter of medical necessity also includes what's needed for the management of that, for that child's condition. And then really, I always will ask providers, please put in there that you recommend that a 504 or an IEP plan is established with the school. And then being able to provide that to the patient then is able to go ahead and provide that to the school. And then the last one with this, we talked about sharing resources when patients run into obstacles. So an MLP referral or local legal aid, like we talked about. The other big piece too is this is all about starting a conversation. So get the conversation started and then also figure out ways that you can help keep the conversation going. And by doing these things, we're not only educating our patients and their families, but we're also empowering them. And we're helping them learn how to advocate for their needs, their child's needs, and helping children learn how to advocate for their needs as well. And number 5 that I should have thought to add to this slide is we want to make sure that we're helping to set expectations and that there are realistic goals. Katie had alluded to that when she spoke about that earlier. It's really good early on to be able to help people understand what that looks like. So Katie, if you could go ahead to the next slide. And then resources for community health centers. The list of resources here, great resources from the American Diabetes Association. The one that I would add to this is there's also one that's called Going to College with Diabetes. And Catherine Gordon, who we just heard from, was actually one of the co-authors on that piece. And I'll tell you, when my son was diagnosed with diabetes in college, this became my go-to book, my go-to resource. And my son was also able to use it. It's very easy to read, very easy to follow. The Epilepsy Foundation has a great seizure action plan. And different states also have different education plans and resources that can be used. So as listed here is the Colorado Department of Education, their asthma care plan, and then there also their allergy and anaphylaxis emergency care plans. So like we mentioned, many states have their own plans. All of these resources that I've listed and also the ones that Catherine has listed and that Sarah will be talking about will be included with the slide deck that will be sent to all of the participants in this on this webinar. So thank you so much. I look forward to reconnecting with everybody when we get to case studies.
Thank you, Gina. Nice touch with the personal, lots of experience that inform all of your advocacy, and hopefully health centers who are participating today get a lot of inspiration from what you just shared. We're going to talk a little bit now about the federal government's role in enforcing the civil rights of students with disabilities, and specifically in the education context. I know we've talked about education and immigration here, but this will be focused on education. And so I want to introduce you to my friend Sarah Fesh-Bachman. Sarah is an attorney with the U.S. Department of Education's Office for Civil Rights, otherwise known as OCR. Prior to joining OCR, she directed the litigation program at the American Diabetes Association. Sarah earned her law degree from American University's Washington College of Law and her undergraduate degree from the University of Nebraska-Lincoln. Sarah, over to you.
Thank you so much, Katie. And it's such a pleasure to be here. I really appreciate the chance to share this time with everyone who's participating. As Katie said, my name is Sarah Fesh-Bachman. My pronouns are she, her. And to provide a visual description, I am a middle-aged blonde white woman wearing a black and white striped dress. And as a disclaimer, I'm in a conference room where the lights are automatic. So it's sort of been going on and off as I've been sitting here in case that's distracting. I hope it's not. Anyway, so the Office for Civil Rights, our mission is to ensure equal access to education and to promote educational excellence throughout the nation through vigorous enforcement of civil rights. OCR enforces 2 laws which protect students with disabilities, which Katie outlined at the outset of this presentation, Section 504 and the ADA. OCR also enforces other federal civil rights laws, which I won't be discussing today, but for the benefit of full description, they are Title VI of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, and national origin. Title IX of the Education Amendments of 1972, which prohibits discrimination on the basis of sex, and the Age Discrimination Act of 1975, as well as the Boy Scouts of America Equal Access Act. There are 2 primary aspects of OCR's work that I plan to discuss today, and they include our work investigating complaints of discrimination and our work to issue guidance and technical assistance and other information and resources to help all stakeholders better understand the laws that OCR enforces. So the first of those 2 is filing complaints and OCR's enforcement process. First and foremost, anyone who believes that an education institution that receives federal financial assistance has discriminated can file a complaint with OCR. The person or organization filing the complaint does not need to be the person or the parent of the person who experienced the alleged discrimination. So complaints on behalf of others are fully permissible. Complaints can be filed online or by mail, and there is a fillable form online, but complaints do not need to follow any particular format. They should include basic information, such as the school or other entity that was involved, the person who has experienced the alleged discrimination, when the conduct occurred, and of course, provide basic contact information so that OCR can get in touch with the person filing the complaint. OCR has 12 regional enforcement offices and serves the entire country. One important note is that a complaint must ordinarily be filed within 180 days of the last act of discrimination. So recognizing that in some cases there will have been multiple instances at play, the clock begins for that filing deadline at the latest act at issue. And finally, in this, this note on our enforcement process is to say that OCR's role in the complaint process is to be a neutral fact finder. Our goal is to promptly resolve all complaints, but we do not act as an advocate for any of the parties. Sometimes there are more than two parties during the process, but to be a neutral fact finder. As I said, OCR has a variety of options for resolving the complaints, including conducting investigations and facilitated resolution processes. And it will really just vary depending on each particular case, what the process will look like. The other aspect that I'd like to discuss of OCR's role in enforcing the law is to issue guidance and technical assistance to help all stakeholders better understand the rights of students and the obligations of recipients to those students. Katie, if you want to advance to the next slide, OCR regularly publishes this technical assistance, and we have issued a lot of it on COVID-19. As it's a new area that everyone, there were lots of questions needing to be answered. So some of the more recent COVID-19 related resources that the department has issued appear on this slide. And I should say that 3 of the 4 resources listed on this slide can be found at the website where you, with the hyperlink that's included at the top of this slide. The first, third, and fourth resources are found on that page along with some other resources. But the first is a letter to educators and parents regarding the CDC's recommendations that came out, I believe, in late February, and their impact on students with disabilities. The second is a fact sheet which addresses the right of students with disabilities to FAPE, and in particular addressing the need for compensatory services that may have arisen for students during the pandemic. The third is a fact sheet that the Department of Education issued jointly with the Department of Justice concerning the rights of students with mental health disabilities who may be at risk for self-harm during the era of COVID-19. And finally, a fact sheet that the OCR issued with OSERS, who is responsible for administering the IDEA on long COVID and students in all school settings. So it addresses K-12 as well as post-secondary students. If you want to advance to the next slide, we also issue non-COVID related resources. And here are 2 examples. The first being probably our most comprehensive general resource. It's a fantastic resource, if I do say so, very thorough, providing an overview of the rights of students in the elementary and secondary setting. And then similarly comprehensive guide in terms of the entire process, but specifically related to ADHD. And both of the links for those two resources appear on this slide as well. And then the final thing I will say is that just last week, the Department of Education announced plans to gather public input on possible amendments to the Section 504 regulations, which have not been revised substantially since they were issued 45 years ago. And so the aim there would be to strengthen and protect the rights of students with disabilities. And there is a link to a page, which I will place in the chat momentarily, that provides more information about this effort and provides an email address where members of the public can share opinions, information, perspectives on what they think that should be included in potential regulatory amendments, issues that arise in their medical practice or legal practice or personal experience. Any and all public comment are welcome as the department undertakes this process. Thank you.
Thank you, Sarah. Look forward to seeing what becomes of that public input process. That will be, I'm sure, a very large undertaking. So we're going to transition now and go through we've got 5 case studies that we think present some different scenarios that your patients or clients may be experiencing. I think 3 of the 5 directly touch on COVID-19. So we hope that that provides a real relevant look at some of the current issues and some that are kind of chronic in nature that come up. And then I will pose some questions to our speakers, to our panel, and get their thoughts on it. I hope as we go through this and as we've been speaking, you'll continue thinking of any questions that you may have, because when we finish this, I will turn it over to the audience and answer any questions that you may have. So I'm going to read these case studies. They are listed on the screen here on these slides, and then I will pose the questions to various speakers. So case study 1 is about Mateo. Mateo came to the United States from El Salvador as a child. He now attends public school in Colorado, where he has struggled. As part of his education and with the goal of improving his English, Mateo has been placed in an English language learner program at his middle school. He's often disciplined for allegedly daydreaming and not following classroom instructions. Eventually, Mateo decides to quit school, deciding it's just not for him, and he won't ever be able to meet the goals his teachers set for him. But because he quit school, he is no longer eligible for DACA, and as a result, he's picked up by ICE and sent to immigration detention. Without access to legal counsel, Mateo deported. So first question I'm going to pose to our immigration guru here, Catherine. So this is a pretty bad situation, but what if his daydreaming and not following classroom instruction is actually due to an undiagnosed disability, such as perhaps profound hearing loss? Maybe he can't hear the instruction. He doesn't know that that's what's going on. He doesn't know to speak up. If Mateo were a patient at a health center, what could the health center do to help him and hopefully avoid this real disastrous immigration scenario?
That's exactly right. I think that this really talks about just kind of early intervention. And so let's imagine that he were in middle school, for example, and a lot of kids coming from different countries, from El Salvador, may not have had access to much education, or may have dropped out earlier, or never really had access to hearing testing, for example. And so if he were a patient at the healthcare center, there could be and if somebody noticed that there was maybe something off with his hearing, they could do some basic testing. And if his mom or if the person who he's living with doesn't feel very comfortable approaching the school, that's a situation where a social worker or a nurse or whoever it is at the healthcare center could perhaps simply just contact the school social worker and say, hey, this kid has some hearing issues. I wonder if we could get him set up for some testing because of his hearing loss, and I wonder if he could be evaluated for IDEA and look to putting an IEP in place or Section 504 protections in place. And that might make the difference between him staying in school and not. As I think Sarah can talk a lot about, is that kids with disabilities are very often subject to more harsh disciplinary procedures than other kids, sometimes because of the lack of diagnosis. And so it might be that if there were that early intervention, he would at an early age be able to get the resources that allowed him to be successful in school.
So as a follow-up, let's change the fact a little bit. Maybe he does have an immigration attorney, but this has still happened. What can and maybe it's the immigration attorney who meets with him for the first time and realizes, oh, this kid has some hearing loss. Like, he's not understanding and it's not a language barrier. There's something going on here. So the immigration attorney identifies that. What can the attorney do, if anything, at that point?
So, I think it's important to identify that that the Rehabilitation Act does apply, and this would be more of a legal, that the Rehabilitation Act does apply in immigration proceedings. There are also other procedural proceedings. There's a case called Matter of MAM, which deals a lot of times with incompetency or mental health, but it also applies to anything that impacts a person's ability to participate in proceedings. And a person can then have what are called like safeguards put in place. And that can and the purpose of these safeguards is to really allow the individual to access full participation in the court hearings that are relevant to them. And so I think that those would be ways of identifying the issues, and that might understanding the hearing loss, that might open up or may not open up different avenues of relief.
Great. Any other comments from panelists? Otherwise, I will move on to the next one.
I can add on to that a little bit.
Sure.
Just to tag team onto what Catherine was saying. I think one of the things that makes community health centers so unique is we will take care of anybody. You don't have to be, you can be documented, you can be undocumented. We don't want to know, as everybody who's on this webinar who works in a community health center knows, that's not important to us. What's important to us is how can we help you get the healthcare, equitable access to the healthcare that you need. And healthcare carries over into so many different places. And in this case, as we're talking about school, it's just those different things about, like at Neighborhood Family Practice, we also are and I know many health centers across the United States also do the same thing, but for refugees being resettled in the United States, we provide their domestic medical examination. That is a requirement for them being resettled. And then the beauty of how we're set up is we are a community health center. So we have ongoing primary care, behavioral health, midwifery, dental, and pharmacy. We can connect them to all of our services. And what we do when we're doing those screenings, doesn't matter if someone's entering our doors through that route, or if they're coming in as an immigrant, a secondary migrant, whoever they are, is identifying and doing a really good job with figuring out what are the healthcare needs of this individual, and then figuring out what can we do to help that. So for anybody who's on this call who works in a community health center, just kind of thinking about that and thinking beyond the walls of the health center. How does this child's, whether it's disability with hearing, or maybe vision, or maybe it's diabetes, asthma, ADHD, how is this going to impact them in school? And Catherine, you mentioned about being proactive. What can we do about this, and how can we help them get a plan set in place in school? And that goes back to starting the conversation. So let's get the conversation started with the parents. Let's get them connected to legal advocacy, to legal aid, who provides legal advocacy, of course, as well as other services. And then how do we build from there?
Agreed. Thank you. So, and I know this is kind of abrupt to just go from child to child here, but that's what we're going to do in the interest of time. So this study is about Maria, who is in third grade at a public school. Maria has leukemia and has been actively receiving treatment for it for the past year. During that time, she's not been able to attend school in person due to COVID-19 and her increased risk of infection and serious disease. Recently, after she finished a round of treatment, Maria's healthcare team determined that it would be safe for Maria to return to the classroom and learn alongside her peers, a decision that has elated Maria, who desperately misses her friends and her school routine. However, this decision was contingent on and dependent upon a policy that required universal masking at Maria's school. Upon learning that the school mask mandate had been removed, Maria's parents asked her school to require masking to keep Maria safe. And the school principal unfortunately said her hands are tied. So difficult situation for Maria and her family. And I guess, Gina, I'll start with you and just ask the general, if Maria was the patient at Neighborhood Family Practice, how would you advise her parents to proceed, or what can the health center do to support the family?
Yeah, I think the hardest thing with situations like this is emotional, right? So there's a physical need, but this is also emotional. This is a child who's excited about going back to school. They believe that things are going to be in place. So many children and adults have suffered throughout COVID with isolation and depression and anxiety, stress, all of that is exacerbated. So the fact now that Maria gets to go back to school and her parents are thinking that the masking is going to be in place and things are going to be safer for their daughter, and now that's removed, I mean, the whole apple cart just got toppled over. So I think the biggest thing is recognizing that and acknowledging that. That's always such an important first step. And then I also think it's really important to help the parents understand and justify the need, and to help set realistic expectations. So with this one, would the whole school need to be masked for Maria to go back to school? So let's say Maria's in first grade and she's only in her first grade class. The whole entire school, let's say it's, I don't know, K through 8, K through 5, whatever, what is realistic and what's not realistic. I think the other big thing too is making sure that the parents are encouraged to have early conversations with the school. So to have meetings with the 504 coordinator to really discuss, what their concerns are, and to figure out what accommodations could be put in place, what could be put into Maria's 504 plan. So getting a 504 plan started would be incredibly important. And then also helping provide that support, like as a provider at a healthcare center, the physician or the nurse practitioner could write that letter that spells out what Maria's condition is, why it's important for her to have certain accommodations in place to help decrease her risk of, in this case, contracting COVID-19. And those conversations could easily include, is the first grade teacher willing to wear a mask? It's people can't be forced to wear the mask, but they can wear masks voluntarily. So I think it's getting that conversation started and figuring out what can be done. I think the other big thing too is making sure, don't assume that Maria is vaccinated. Making sure that, or depending on what the age of the child is, that they're vaccinated. As community health centers, we've done a great job across the nation with getting people vaccinated. And we do offer, all of our community health centers everywhere are offering COVID vaccines.
Very, very important point. Sarah, I'm curious, based on the department's various COVID guidance, as you mentioned, there's a lot of it. What are some of the relevant considerations here?
Sure. So first, I just want to start with the legal obligation that school districts must make reasonable modifications when necessary to ensure equal access for students with disabilities, absent a showing that the modifications would constitute a fundamental alteration of the program. And so determining whether something is a reasonable modification is always going to be a fact-specific determination. And so responding the way that this principal did without considering the request would not be consistent with that legal obligation. And the federal government as a whole has made clear that depending on the circumstances, some degree of masking of students and staff may be necessary as a reasonable modification. It's really important to remember that the ADA and 504 protect the rights of students with disabilities to have equal access to school, which means that students with disabilities have the right to access their school without taking on a far greater risk to their health than other students face. So some of the factors to consider include current public health guidance as it has changed throughout the pandemic, the student's individual medical or evaluation data. What kind of information is the student sharing with the school to explain what their needs are? The circumstances of the local community and the particular school, what other reasonable modifications or prevention measures are in place at the school. These are just some of the factors that could be relevant to that fact-specific, individualized determination that the law contemplates.
Right, Katie, I'm sorry, before you move on to the next one of the biggest things that we can do at the Community Health Center is get them connected to somebody from legal aid or somebody who has that understanding and background. So I should have started with that one because that was the easiest and most obvious one, but it's that partnership.
I was going to say, no problem reinforcing that. Thank you, Gina. Go ahead.
I also would just kind of mention, I'm not sure if folks are aware, but the Protection and Advocacy Network called, usually it's like Disability Rights Texas, Disability Rights state name, are phenomenal resources. And so in every state, there's an organization that works on those access issues. And I think that they are sometimes not well known, but the work that they do, whether it's Disability Rights California, every single state has one, and they just do phenomenal work and do phenomenal training. And so I just want to shout out to the really, really good work they're doing, because legal aid might not do that, but the disability rights organizations will.
Very good point. And you will hear me reference that multiple times, in particular when we get to the last webinar in this series, and we're talking through some of the nuts and bolts and the resources that can help you build a medical legal partnership around disability issues, discrimination issues. Thank you. So the next case study is in a slightly different school setting. This one is about Tamara, who's just entered her sophomore year of college at a large state university, where she's excited to join a sorority and continue the success she had as a freshman, starring on her school's soccer team. 2 weeks into the fall semester, Tamara is feeling unusually fatigued and thirsty. Although she initially believes this is a result of her grueling soccer schedule, her parents convince her to visit the campus health clinic to get checked out. She's unable to get in quickly, and since she's feeling terrible, she lets her roommate take her to the local health clinic downtown, where she's diagnosed with type 1 diabetes. Back on campus, she meets with her coach to share the news, and she's told she cannot participate anymore because, quote, she might pass out. Frustrated, Tamara tries to manage her diabetes by herself, but experiences low blood glucose during an exam, and she performs poorly. She returns to the health center overwhelmed, depressed by how her first month back at school has gone. So I'm feeling for Tamara. I played soccer, and that just does not sound fun. Gina, I'm curious, same sort of general question. If Tamara came to Neighborhood Family Practice, how would you advise your team to help her?
Yeah, so this one really hits home with me. As I shared earlier when I was doing my introduction, my son was diagnosed with type 1 diabetes 3 weeks after he started college, which was four hours away from where we live in Cleveland. And I think one of the biggest thing is kids who are in college are transitioning, right? So many of them have lived at home, they're transitioning to adulthood, and a lot of the things that their parents may have been helping them with if they already had a pre-existing condition like diabetes when they were younger, now they're figuring out how to manage it more independently. And if it's a new diagnosis, now you're away, right? You're away from your support system. So it could be your family, it could be your friends, it very well might be, and a lot of times is your provider. So I think the biggest thing is Tamara definitely needs an advocate. She definitely needs somebody to help her navigate everything that's going on, both with her new diagnosis as well as with getting things in place at school that will help her be able to participate academically, but then also be able to participate in things with sports in a way that's safe. So the first couple of things that come to mind is, of course, with being community health centers, the first thing that we're going to focus on is the control of her diabetes. Someone with type 1 diabetes very well need to be referred out to a specialist like an endocrinologist. I don't think I know the majority of community health centers do not have endocrinology on staff. They might have some part-time endocrinology, but we're all connected to specialists. So getting Tamara connected, and then also helping her get the paperwork that she needs to then be able to go to the colleges. It's usually the Office of Disability Rights. It's and I'm smiling because Catherine was the author on that Going to College with Diabetes book or reference that I mentioned earlier. And that's such an important piece, and it'll talk in there about getting connected as soon as possible. You want to get a plan in place. So we want to encourage Tamara to get a plan in place, to get a 504 plan in place with school, hopefully before things are going bad, because that's going to help put those accommodations in place that'll help her be able to make up a test if she has a low blood sugar during a test or a high blood sugar during a test. That will, by getting connected to the Disability Rights Office, the Disability Rights team will be able to help her navigate everything else that's going on with the college or university. So they'll be able to help her have conversations with faculty, help her have conversations with the coach or the athletic. And if those conversations aren't going the way that they need to be going, that the staff from the Disability Rights Office can be able to jump in and serve as Tamara's advocate. So I think like one of the biggest things too is whether it's us at the Community Health Center being able to support what she needs in terms of the letter of medical necessity, the medical care plan, assistance with the 504 plan is needed, or encouraging her to connect with her endocrinologist. Those are big ways that we can help out.
Thanks, Gina. Sarah, I'm curious, let's say that Tamara and her parents are not able to convince her soccer coach to let her continue playing, and they decide to file a complaint with OCR. What can they expect from that process?
Sure. So I'll put this link in the chat after I'm finished, but for anyone with questions about OCR's process for complaint resolution, OCR has a comprehensive publication called our Case Processing Manual. So any possible question you could have about what the process looks like will be addressed very likely in that publication. But just to give sort of a broad brush overview of what the process looks like, if Tamara decides to file a complaint with OCR, she can expect that OCR will initially respond to the complaint to seek additional basic information from her. In all cases, OCR needs to determine that it has jurisdiction to investigate and that there's essentially sufficient evidence that discrimination may have occurred before proceeding with an investigation. So if, for example, the discrimination occurred more than 180 days ago, unfortunately, in most cases, OCR would not be able to continue with an investigation. If the conduct doesn't involve, if it doesn't involve conduct by a recipient of federal financial aid, or if for some other reason OCR does not have jurisdiction, then we would just close that complaint. But assuming that we did have jurisdiction to investigate, then OCR could begin an investigation, in which case the enforcement staff would conduct interviews, request data, that kind of thing. But on the other hand, the recipient might be interested in proceeding to a resolution process, in which case an investigation of the facts may not be necessary if the recipient is interested in just resolving the incident. In most cases, there's evidence on both sides. And so if it is conducting an investigation, OCR would need to determine if the evidence supports a finding of discrimination by the standard that is referred to as the preponderance of the evidence standard in the law. And the other thing that Tamara can expect is that investigations can take time. OCR strives to be both prompt and thorough in its investigations, but sometimes they take longer than a complainant might otherwise expect. So those are just some general basic things to keep in mind.
Thank you. Good to have that insider view of what to expect. Okay, we have 2 more case studies and I don't want to run out of time, so let's get to those. The next one is about Josh. He's a high school student in New York who attended school remotely for parts of 2 school years due to the pandemic. During that time, he experienced the loss of a grandparent to COVID-19. For the first time, he's developed severe depression. Josh's parents tell his school principal about his depression, but the principal does not refer Josh for any evaluations. Instead, the principal tells Josh's parents that all students are struggling because of the pandemic and remote learning, and says that Josh just needs to toughen up. When his parents plead with the principal to provide him with help at school, the principal suggests that the parents should hire a private tutor and find a psychologist for Josh. So that is a tough situation. And I guess, Sarah, I'm curious, you know, what are some of the factors here? What are some of the things that OCR would consider in an investigation if Josh and his parents move forward with a complaint?
Sure. Of course, all investigations are different, so there aren't any universal considerations other than those that are necessary to determine that OCR has jurisdiction to investigate. But let's say that OCR were to receive this exact paragraph in the form of a complaint, this information. We might, for example, want to know more information about how the request was made or what exactly the parents said in their request. We would certainly be interested in finding out when the request was made, in part because it could affect whether the complaint is timely. As I mentioned in my description of OCR in the beginning, OCR's role is to be a neutral fact finder and thoroughly investigate complaints. So if this is what we received in the form of a complaint, OCR could discover through the course of its investigation that there are contradictory facts, and perhaps the principal provides copies of emails that clearly refer the parents to the 504 coordinator. And so in its investigation, OCR would be looking into, for example, there was in fact a refusal to evaluate the student, and whether all of the facts that are alleged in the complaint seem to be true based on all of the evidence that it's able to gather in its investigation. Assuming that all of these facts on the slide are confirmed through OCR's investigation as true, and there aren't contradictory facts that call them into question, it would be relevant to consider, for example, how long the student has gone without an evaluation and what the impact on the student has been to not be evaluated for potential services for that period of time. And these types of considerations could be relevant to, for example, whether compensatory services are something that the school should provide. So those are just some examples of things that OCR might be interested in finding more about.
Well, it makes me hope that Josh and his family file a complaint so that can move forward. Okay, last one is back into the immigration context relevant to the pandemic. So Alejandro has been detained at an immigration facility since January of 2020. During that time, he was infected with COVID-19 twice due to poor health and safety procedures implemented by the private prison company that runs his facility. When he arrived in the US, he did not have any chronic health conditions. Since having COVID-19 twice, he has been experiencing symptoms of what is commonly known as long COVID, though his facility has ignored this. His immigration attorney is trying to secure medical care for him, but as Alejandro has been detained for more than 2 years, he does not have a regular healthcare provider who can help advocate for him. So this is a pretty tough situation, and I'm curious, pose this question to Catherine. What options does the immigration attorney have for addressing his new disability?
Yeah, so I think that this is really goes to the importance of developing wherever we are medical legal partnerships. This is unfortunately a pretty real case where one of my clients who's mentally incompetent and has traumatic brain injury, he ended up with COVID, and he ended up with actually we're still learning about COVID, but his pancreatic functioning was just for a different reason than diabetes was destroyed. And so he really has to take medication every day for the rest of his life. But when I initially was speaking with him, he was giving me general complaints, but I didn't really understand this. And what I did was I actually contacted a doctor at a wonderful community health center in the area. And she was able to review his records, and she was actually able to identify these are the issues that are happening. And because she was able to identify that and write a letter, that got him evaluated with gastroenterology to get him started on at least some amount of care. So I think that that's just like an extraordinary case of how a doctor or other healthcare professional can work with us. And we're in the process of developing Care Coalition, and other organizations are in the process of developing more partnerships with healthcare professionals across the country on that. And I think in terms of the legal options, this is really an area where the law is developing. And I think like one really good thing that's happened that just has been announced with more publicity in the past few days actually is a ombudsperson who is actually looking into detention center standards, and it's possible to start to do more complaints and so forth. And I'm actually in the process of doing some of that for my clients. And again, I think really getting the perspective of the healthcare professional who is viewed to be more independent and perhaps a little bit more neutral than the advocate can really make a difference there. There's a lot of the care is provided by the Health Services Corps, so folks who are actually part of HHS, and they are folks who are civil servants who provide care. They don't provide the daily care, but they do provide some of the management. And I think that you could be in a really good position of coordinating care between the different parts of HHS to improve care. And I'm going to put in here just the link for the DHS Office of Civil Rights and Liberties, where you can make a complaint, and then also the ombudsperson, where you can also make a complaint. And again, I am really, really happy to discuss offline with anyone who has questions on immigration issues.
Thank you, Catherine. I'm going to move us on from here simply because we are very quickly running out of time. But thank you for all of this good discussion on these cases and laying the groundwork for that. I don't see any questions in the chat box or the question and answer box, but we did have one submitted in advance that I wanted to make sure that I acknowledge. Somebody asked a question about, are there standard practices in the field to address the legal requirements of the Developmental Disabilities Act of 2000? And I just wanted to say that particular law is one that, among other things, authorizes programs to support individuals with developmental disabilities and their families. And one of the authorizations, I mean, those programs range from research and delivery innovations to investigating cases of abuse and advocacy, but it also authorizes the state protection and advocacy system that Catherine mentioned a couple minutes ago, that I mentioned is a really great resource that you'll hear us talk about over and over again. Each state has a protection and advocacy organization dedicated to protecting and advancing the rights of people with disabilities, not just developmental disabilities. So, and that includes providing legal support. So I think I'd encourage the person who posed this question to reach out to the protection and advocacy in the state to have a more in-depth conversation than I can get into today. That law is not primarily to address discrimination, but it certainly is relevant to a large population of people. So I don't see any other questions, and I apologize that we don't have a lot of time, but this gives me a great opportunity to encourage folks to keep thinking about your questions, think about the topics that we have been talking about today that we talked about 2 weeks ago. Our next webinar is in 2 weeks, and it is going to focus on what I've called the new kid on the block, the newest disability, which is COVID and long COVID in particular. We've touched on it a bit today in this focus on pediatric patients. But as everybody probably knows, it is a very hot topic, and we hope to dig into what some of the emerging issues are. But related also, I will be holding some office hours over the next few weeks to give you an opportunity to ask any follow-up questions that you didn't have a chance to ask today, or that come up as you process some of this information. Maybe you're going to access some of these resources that are in the chat box. And please, we will circulate and post information with the dates and the times, but it'll be an opportunity to drop in and ask me any questions. And if necessary, I can direct them to some of the other panelists and provide follow-up on that. But please keep thinking about questions. We are here to provide as much information as we can. And with that, I will thank you for joining us today. I can see in the chat box, please do let us know what you thought of this webinar with the evaluation. And that will conclude today's webinar.